firstly, I just wanted to share a duty of care case. Now, it's a fairly old one, but it's one that, whenever we talk to people about it, and we've had a couple of questions this week about duty of care, so we thought this wouldn't be a bad one to actually share with you. And, when we talk duty of care, it's actually the obligation of an agent to avoid acts or omissions which are reasonably foreseeable that will cause damage to another person. So let's have a look at this case study. For a tenant to be successful in an action in negligence or against, a landlord or an agent, the agent's breach of duty or the landlord's breach of duty must cause damage to the tenant or to their property. So, that's their personal property. Now, Schedule 1 in the Property and Stock Regulations actually states that as an agent you must exercise due care, skill and diligence in carrying out your responsibilities under the terms of your agency agreement. Now, being mindful of your duty of care that's owed to your landlords and your tenants and the effect on the real estate agency and its exposure to litigation. So that's something that you've got to work with on a daily basis in every single arrangement that you come into. So now if an agent doesn't have the expected skill levels or doesn't act with care and diligence, the law will always protect the victim, and that victim will obviously in that particular situation be your tenant. And there was a case that was published at the end of just a few years ago now, about 2015, where a Sydney tenant sued a real estate agent for negligence as a result of a slip and fall in a rental apartment. So, just a standard accident that occurred. Now, it went so much further than that. So the tenant lived in an apartment, they sued the owner and the managing agent of the rented premises. Now, the tenant slipped on a pool of water which had leaked from the shower recess onto the floor, causing her to fall, and suffered a significant laceration to her right ring finger, an injury to her lower back and her left knee, as well as psychological consequences that arose from the accident. She required hospitalisation, surgery to her hand due to the loss of blood at the time of the accident. So, not very pleasant at all. And certainly an accident that no one wants to have or no one wants to even hear about. Now, it was an allegation of negligence then against the owner and the real estate agent, was that they never took reasonable steps to ensure that the premises were safe, fit and habitable, in a state of good and serviceable repair. So there's where that sits. And the tenant claimed that they failed to repair, replace and prevent water leaking from the shower recess in circumstances where both the defendants knew, so both the landlord and the real estate agent knew, by way of the many complaints that the tenant had made, that the shower recess was actually leaking and was unsafe. So the tenant had made those complaints and asked for something to be done. So, the whole case went through, photographs, expert evidence was provided to substantiate different points of view of the negligence against the landlord and the managing agent. The tenant's lawyer believed that their client, the tenant, would succeed against one or both of the defendants, the landlord and the managing agent, in the proceedings because of the numerous prior complaints with regard to the leaking of the shower recess. So saying that the complaints were made, nothing was done. So really very, very simple in terms of the activity and the cause and effect type situation here. So, there was, references to doctors, there were specialists, there was medico-legal evidence and reports, and, ongoing issues around the knee, the lower back, the hand. So, it was very much a drawn-out matter. Now, obviously, the owner and the managing agent denied liability in all of this in respect to negligence. They disputed the medical experts. They had the tenant, examined by their own medical experts. It was listed for a hearing, which is obviously the pathway that it takes. However, they all agreed after looking at all of the evidence that it would be listed for a settlement conference. So rather than taking it to court, and obviously that's another huge expense for everyone involved, they wanted a settlement consultation to have a look at what could possibly be settled. Now, the tenant had claimed damages including non-economic loss, full permanent impairment, pain and suffering, past and future out-of-pocket expenses, past and future loss of wages. So, a whole range of loss of superannuation, Now, the defendants actually agreed to settle this claim. The tenant was awarded substantial damages because of her injuries, her permanent disabilities, and the losses that were flowing from the actual accident. Now, what we have here, this case established is that there are significant legal obligations and duties of care, and we all know this. We've all talked about it for years, and from whenever you first started in the industry, it's always been something that you've been talked to about, probably by your licensee in charge and by more senior people as you've come up through the industry. And those legal obligations are placed on the owner to ensure that the rental premises are fit, habitable, safe, and in a good state of repair. Now we have the landlord information statement that reminds the landlord that is their obligation. This duty of care also places a significant obligation on agents who receive complaints from tenants in relation to rectifying premises so as not to create a risk of injury or any type of risk whilst they are residing in the unit. Now, if that doesn't happen, if the agent doesn't follow what they've been, what their role is, which is to, address those issues, and they fail to act on the complaints, they fail to act on the requests for works to be done, then, the real estate agent will obviously, as evidence in this particular case, be found negligent, and damages will be, paid by both, and as it was in this case, by both the landlord and the real estate agent. So not a good place to be in, which comes down to your processes and how you actually run your agency. So a really important issue, and I know I've talked that one through a fair bit today, but I think it's a really important issue to remind ourselves of, particularly as we come up to a holiday period where, when you might think, oh, no, we've got time to fix this, we've got time to do that. Yeah, not an issue. We'll get it done after Christmas. Look at each issue and look at how urgent it is. Look at the fit and habitable. Look at the, what risks there are arising out of this. And obviously a leaking shower is something that clearly has a risk associated to it. So guys, have a look at your repairs and maintenance procedures and make sure that they take into consideration all of those issues.